Hi, I'm Reed Bloodworth, founding partner of Bloodworth Law. Today I'm going to take a moment to discuss trust litigation. Well, first issue we should address is, what is a trust? A trust is a legal creation whose purpose is to hold assets for beneficiaries. A trust is controlled by a trustee. There are many types of trusts. Some of the more common types are revocable trust, irrevocable trust. A revocable trust means that the grantor, the person who is putting the assets into the trust, controls the trust and controls those assets for his or her lifetime. An irrevocable trust, the grantor puts items into the trust, but relinquishes control of those assets, and the trustee will manage those assets for however long the trust is designated to last. Trusts are very beneficial in terms of estate planning. Items that are in trusts avoid probate. Probate can be lengthy, can be expensive, and trusts are a way that lawyers avoid that process for certain assets. Probate litigation arises in a multitude of fashions. Some of the more common types of probate litigation involve beneficiaries who believe they were improperly left out of a trust, or perhaps a trust was amended and certain beneficiaries were left out, some were added, and the disputes arise. So for example, let's say father has two children. He had a trust, and the two children were the equal beneficiaries of the assets in that trust. However, later in life, father remarries. Father is somewhat weak, perhaps he's sick, or perhaps he suffers from dementia or Alzheimer's. And the stepmother takes father to an attorney, and she has father create an amendment to the trust, removing his biological children as beneficiaries, adding herself, or adding herself and her children. This is a very common occurrence in terms of trust litigation. In this situation, the biological children may bring an action against the trustee to have it set aside for multiple reasons. It could be lack of capacity, it could be undue influence, it could be tortious interference with a testamentary expectancy. Some other causes of action pertaining to trust litigation in that context may include an accounting, because the beneficiaries or would-be beneficiaries want to know, where did the assets go? And a trustee's duty is to supply accounting to the trustees, or to the beneficiaries, excuse me. So in that scenario, my law firm, would represent either the trustees in defending a lawsuit brought by beneficiaries, or could represent the beneficiaries bringing the suit against the trustees. This is just a common scenario for trust litigation. So at Bloodworth Law, we represent beneficiaries and trustees. We represent them both as plaintiffs and defendants. Again, my name is Reed Bloodworth, the founding partner, Bloodworth Law. Give me a call. Let's talk about what happened to you.